District of Ohio, the Honorable Jeff Myers, presiding, is now set. Please be seated. Good morning. Welcome to the First District Court of Appeals. We have two cases on the docket to be argued this morning. We are a little late getting started because we were waiting for appellant counsel in our first case. He has not yet arrived, so we are going to go ahead and start. We weren't able to reach him. So, Mr. Talon, I know you are here on behalf of Applee. You have 15 minutes if you'd like to take advantage of it this morning.
Thank you, Your Honor. I don't expect to be that long.
All right, and please come to the podium. I will keep your time, and whenever you're ready, you may begin. Oh, and by the way, I forgot to say, this is the case of Blue Ash Body versus Grange Property.
Good morning, Your Honors. Mitch Talon on behalf of Applee Grange Mutual Casualty Insurance Company. And Mr. Becker and I have been in various courts of appeals before, and we've been in the Sixth Circuit on this issue. And I referenced that decision in my brief, in Applee's brief. And excuse my voice this morning. That would be the Blue Ash versus State Farm case that I cited on page 16 of Applee's brief. In short, Blue Ash took assignments from multiple customers totaling about $18,500, and I won't dwell on the facts of this case. The assignment is interesting because, and the assignment was included in a stipulation of facts filed with the trial court. It should be in the record of the case. The assignment references not only damages that have accrued in the past, but that may accrue in the future. The West Broad Chiropractic case, an Ohio Supreme Court case, stands for the proposition that if there's no judgment, if a claim is not reduced to a binding settlement, a claim cannot be assigned. And as a matter of public policy, the Ohio Supreme Court referenced body shop litigation in the body of that decision.
So basically, the loss amount has to be a fixed amount of money that's assigned.
Correct, either by judgment or a settlement.
And in this case, I know you didn't want to dwell on the facts, and I don't know if all of this is in the record. I did look at the record. But so Grange authorized a certain amount that they were willing to pay to get the cars fixed, right?
It's not predetermined. It's a working process between the insurance company and the body shop. And the reason for that is that when the vehicle first comes into the body shop, they do a visual estimate. When parts come off the vehicle, they then see additional damage. So there tends to be a supplement. There's often a second supplement. So it's an ongoing process.
Okay. So there was no fixed authorization of a certain amount in this case?
When a vehicle comes into a body shop, there is not a fixed amount.
Okay. So did Grange authorize that Blue Ash could fix the cars knowing that, I guess my question is, what was Grange expecting to pay?
So insureds can select any body shop they wish.
Okay.
And insurance companies have their own body shops, which go by various names, but in the body shop industry, they're called preferred shops. State Farm might call it Select Service. Grange might have another name for it. If you go to one of the preferred shops, then there's a better working relationship between the body shop and the insurer.
Was Blue Ash a preferred shop?
No.
Oh, okay.
So customers can take their vehicle to any body shop they wish, but some body shops are more aggressive or, without meaning to sound harsh, opportunistic. And the assignment in this case referenced many of those sundry fees that have nothing to do necessarily with the repair of the vehicle. Administrative charges, storage fees, even a prorated amount for their shop insurance.
So if a customer decides to go to a non-preferred body shop, as apparently is the case with the Blue Ash body shop, and what's the agreement between Grange and the customer as far as what Grange is going to pay? I mean, is Grange willing to pay whatever that shop charges, or is there a limit, or how's that work?
It's set forth in the policy, which was included in the stipulations, but Your Honor, it boils down to a reasonable amount to repair the vehicle.
Okay. So it's never a known amount. I mean, it's not like there's an estimate that's presented and Grange is like, okay, yes, we're going to pay that amount.
So when you really wade into the weeds on this type of thing, body shops and insurance companies use estimating programs. And sometimes there are variations between the estimating program that the body shop might prefer to use and that the insurer prefers to use. And that's where the body shop and the insurer have to meet in the middle. And insurers usually get along with 95% of the body shops out there, and they mediate and work in the middle of any disparities between the body shop's estimates and the insurer's estimates. And then there's the 5% out there where they're aggressive body shops and they charge for a lot of things that insurers won't pay for.
Okay, thank you.
I got up from Columbus, Ohio at 5 a.m. Mr. Becker's not here. He's a friend of mine. I think that really we could have submitted this on the briefs. It's really just a matter of maintenance and champerty at the end of the day. Pilkington has 3 exceptions and 2 of them apply. When the interest is changed, then a contract cannot be assigned. Also, when the insurer specifically or party to the contract specifically forbids any assignment, that applies here too. So 2 exceptions to Pilkington apply. That the interest has changed and that the insurer, Grange, expressly forbade assignments. Thank you very much.
Thank you. We will take the case under submission and give you a timely written opinion. We appreciate your being here today. Thank you. The next case on our docket this morning to be argued is Cook versus Metropolitan Sewer District. Mr. Neff is here on behalf of appellant. Mr. McIntosh is here on behalf of appellee. Mr. Neff, you will have 15 minutes total to argue this morning. Would you like to reserve any time?
Yes, Your Honor. 3 minutes, please.
All right, and I will keep your time and let you know when you're at your time.
Thank you. May it please the court, opposing counsel. We're here for 2 reasons. First, the trial court determined an issue that was not before it in the motion to dismiss. Second, it determined that a department within the city of Cincinnati is legally capable of being sued, which is not.
Is that issue properly before us?
Your Honor.
Because of the, let me even be more specific, because it's not a final appealable order?
Your Honor, I typically would not be. A motion to dismiss to remove a party based on the fact that it's not sui juris would not typically be before the court. Wouldn't be immediately reviewable. In this case, I cited 2 7th District cases, Pinkins, and in that case it determined when sui juris and immunity are both brought up, that in that case it could be appealed because sui juris is a preliminary question to immunity. In that case, it is a final appealable order in that sense, and the court is able to review it.
Isn't that a little bit different because here there are more than one party and immunity, which would be a final appealable order. Isn't this a little bit different than that case?
There are some differences, Your Honor, but I would still point to the fact that they both involve immunity and sui juris.
But the parties actually raised immunity in that case, right?
That's correct.
And in this case, you're saying that the judge sua sponte decided it.
Yes, that's
So
correct.
that doesn't take that case out of our consideration for why this is not a final appealable order?
Well, that does distinguish the 2 cases, but I would point out that, Your Honor, the fact that the trial court spent 3 paragraphs over half of its order discussing immunity while it wasn't raised by either party, that in fact did make that a final appealable order in the sense that it determined it was a proprietary function. It went through the full analysis of that without either party having the advantage of discovery, having the ability to fully brief it.
And your position is you're precluded from filing a motion for summary judgment because it's been finally determined by the court already?
That's correct, Your Honor. So the concern for the city would be if go through all the way through discovery, the court's time, judicial efficiency is obviously a concern, file motions, and then have the potential of res judicata being raised as the fact that immunity was already determined up by the trial court. It just would not be the best use of time. So the concern is, if that can be raised, and based on how detailed it was in the court's order, if this court could correct that by reversing the trial court, then the parties could go through discovery. And if a motion is merited, but based on the limited facts of the complaint, that's not clear yet. So I can't say with certainty we would raise that, but would like to have that available and not be precluded by res judicata. And I think I've raised it quite well in the brief, but I will again reiterate that, again, there was no oral argument. Immunity was not in any brief. There were limited facts. We were limited to the complaint, of course. So it seemed strange that the court would sua sponte make that decision that immunity didn't apply and have, again, over half of its order dedicated to that issue itself. So the city did have to appeal because of that issue of concern for res judicata. And in regards to sui juris, MSD is not a separate legal entity. It is a department within the city. It's a county sewer district that's managed and operated by the city as a department. And I cited to numerous cases that indicate that other departments of cities have been determined not to be sui juris and not separate legal entities capable of being sued. And I think those are applicable here.
But MSD doesn't always raise this argument, right? MSD is just consented to being sued previously, right?
That's correct, Your Honor. There were some cases where MSD was plaintiff or defendant, and I have no reason to know why that occurred or why those weren't corrected, but I would indicate that personal jurisdiction does need to be established with every case. So I think what plaintiff was trying to argue is that the city should be precluded from getting MSD out based on previous cases, but I would argue that that's attempting to say that the city can alter personal jurisdiction rules and rules of civil procedure. Previous cases shouldn't change those rules. Every case, personal jurisdiction should be established.
Let me go back to something I asked early on. If the court had not sua sponte raised the immunity issue and all we had was the sui generis argument, you would agree that that would not be a final appealable order. You'd have to wait till the end of the case to appeal that.
Yes, Your Honor.
Why is it different because the court sua sponte raised immunity, which, as I said, is an appealable issue on its own?
Even though the parties did not raise immunity, the city would argue that because the court, it wasn't a simple one sentence throw in immunity because a case that involved sui juris discussed immunity. It was.
Let me interrupt you. I think I asked the wrong question. Why shouldn't we sever the immunity piece from the standing piece?
Your Honor, again, I'd point to, I know 7th District is a different county, but I would point to that to indicate that when those two issues get tied together, the sui juris and immunity, that it is appropriate to consider both at this point.
Wasn't that, and I might be misremembering this case, but wasn't that because there was one entity and the court felt that it had to decide first whether there was standing before it could decide whether there was immunity? In this case, the immunity goes to the city, which is a different party than the standing, and so we don't have those same reasons to decide both, do we?
You're right, Honor. That is one way to distinguish the case, but I would ask this court to extend, based on the facts here, because even if the court determines that MSD is not sui juris at this level, plaintiff still has the ability to go after the city and county. They're not precluded from still pursuing the case further, so they're not harmed in any way by having MSD removed as a party from the case.
Thank you.
If there's no further questions, I'd reserve the remainder of my time for rebuttal.
Thank you for the question.
Thank you.
I will do the math and let you know when you come back how much you have. Mr. McIntosh, you have 15 minutes.
Thank you, Your Honor. Good morning, everyone. Pleasure to be before you. The court raises a singular and important issue, and that is that it is probably not ripe. If you refer to the trial court's decision, she spends time talking about immunity, but she ultimately finds on the issue of sui juris. And
Well, but she did make a finding as to immunity, did she? Did she not?
I didn't see, I think as I looked through it, and I just double-checked it, at the end, she finds, instead MSD argues that this court does not have personal jurisdiction because MSD does not have the legal capacity to be sued. This is on page 3. However, for the reasons stated above, the court has determined MSD has the legal capacity to be sued. So the decision there and in the very first paragraph of her decision is solely on sui juris. I know she talks about, she goes through that, and that was because in the reply of MSD and the city, they mention immunity, but it really wasn't the issue that was at hand, or I think that the judge did. I think she was recognizing the reply, but as I indicated in my brief, that's really 99% dicta, as it wasn't moved in the first place.
Well, but if the city didn't appeal it, wouldn't they have lost their ability to challenge the immunity decision?
I don't think so. I don't think so because first, it wasn't raised appropriately. I mean, they didn't raise it, so it wasn't an issue before the court. I think they may have had an indication of how the court would potentially rule on it. I think she was pretty clear about that. But I don't think that it was to the extent that that it was a decision of the court. Secondly, this appeal is about sui juris. It's not about the immunity. So they're still appealing to you regarding the failure to have standing to be sued or sued. So just in the composition of.
Well, that goes back to my question to opposing counsel. Is that a final appealable order? Is that piece of it a final appealable
Correct.
order?
I don't think so, just because I think that the issue was only raised as an aside in a reply. The court's response to that aside not being part of the motion was simply dicta. So I don't believe they were intertwined to the degree that it would create a final appealable order.
Now, if we were to get to the issue, I mean, didn't the court basically just rely on the fact that MSD has consented to being sued in prior cases and therefore they can be sued in this one?
To the extent that that is accurate, she did. I think it's different and kind of curious when you say personal jurisdiction needs to be determined in every case. Of course it does. But that doesn't mean that stare decisis or the rule of law or how these parties generally act doesn't go into that determination, right? So you don't get a fresh bite at the apple every time. I think the fact that they have actually sued, okay, not just
consented,
sued,
yeah.
but they stepped into the ring more than once. And I understand this council may not have been involved in that rationale, but that's not the problem. The problem is that the entity has stepped into the ring, caused judgments in their favor. I don't know if they've collected on them, but my point is they have acted as if, not just responded and maybe didn't raise the issue. So this goes a step beyond that. And I do believe there's a case that this court found. Let me get to that. I had that one. In Bibbs versus Synergy, 2002, Ohio 1851, this court found that MSD is a political subdivision and subject to that. So I think to some extent this court's already determined this issue if we do get to the merits. But to that extent, I'd also like to only comment on some of the cases cited by the appellant. All of the cases they cite talk about law enforcement, municipal courts, city councils, certainly not sewer districts. The establishment of the sewer districts under Revised Code 6117 contemplates, if you read through that, a singular owning entity, which is not the case in Hamilton County. So what we do is we then fall back to the Pinkins argument, which they cited, which talks about suing a multi-jurisdictional unincorporated nonprofit, okay? And that can be sued. So in the essence that it's not a single entity, this is a multi-jurisdictional entity, it is able to be sued. So it has sui juris. So I think that it's important to look at Pinkins from digging into that case. That again was a law enforcement task force. And their theory was that the multi-jurisdictional unincorporated nonprofit association sui juris didn't apply to the law enforcement entity because its nature was law enforcement, and it's pretty well determined that that is someone or an entity in and of themselves that are not sui juris. In this situation, as different from the specific finding in Pinkins, is that this is a multi-jurisdictional entity who is composed of people who are sui juris. So the Pinkins Court, by its logic, would also find that MSD would be able to sue and be sued.
Let me ask you a question about that, Mr. McIntosh. I'm looking at the prior complaints that the trial court relied on, and it appears that each time the Metropolitan Sewer District entered the arena, as you call it, they did so as an agent for the city of Cincinnati. Does that make any difference?
I don't think so. Again, they're acting, even as an agent, they're acting independently. And I want to double check that because I think
Yeah.
at one point they said they entered as an agent for themselves.
Yeah, I'm just looking at the two. It's
Get to that case.
2005 case, well, they're both 2005 cases where it says Metropolitan Sewer District, an agent of the city of Cincinnati, a municipal corporation.
I don't think it does, in as much as they're standing forward for it. So, yeah, they say Metropolitan Sewer District, an agent for the city of Cincinnati Municipal Corporation, agent for Metropolitan Sewer District. So they're standing on their own, using a lot of words they shouldn't have used probably, but they just said it. The fact is, though, they were the plaintiff.
I am curious, I don't know that this answers any questions, but the city is representing MSD and the city of Cincinnati, and then a separate, the prosecutor's office is representing the commissioners. The commissioners are in because of their relationship with MSD, or is that right? And they haven't appealed anything at this point.
Correct. And to that extent, I wouldn't just say that the representation alone shows this agency that the appellant says creates denies the sui juris. If it's not a conflict of interest, they could be represented by the same entity and still be separate, or same council, but still be separate entities.
Right.
That's all I have.
Thank you for your argument. I have done the math. Mr. Neff, you have 10 minutes remaining if you'd like to use it.
I don't think I'll need all that, but thank you.
Mr. Neff, if, may I ask the same, I'll ask you the same question I asked Mr. McIntosh. I don't have Mr. McIntosh's complaint here in front of me, but just assume, for the sake of argument, that he had sued the Metropolitan Sewer District of Greater Cincinnati, an agent for the city of Cincinnati. Would you be here making the same arguments?
Yes, Your Honor.
Okay.
The city would argue still that MSD should not be a party in the case.
Even as an agent for the city?
Yes, Your Honor.
Okay.
In some of those cases that plaintiff did cite in his reply brief, Bibbs, that case, this court did review that case, but I would like to point out just that the court essentially reiterated a city statement regarding immunity with that as a division of the city, MSD has the same governmental, as a governmental protection. So it's an entity for the purposes of immunity, not for being sued. So I think those are two different things. That's how I would distinguish Bibbs.
How do you respond to the fact that MSD has actually sued others?
Those were unreported cases, but to the best I could review them, Your Honor, it appered that I don't have the list in front of me, but I feel like a good number of those didn't go all the way through litigation. So I don't know if there's a reason they were not fully litigated or if they were dismissed.
They look like collection cases.
Okay, thank you, Your Honor. But I would say that at least in some of the other cases that were cited, the city and county were the ones that were litigating the case. And MSD's name was not dismissed or not requested to be dismissed. I'm not sure why, but they were never in any of the decisions or the appeals that occurred. In fact, one of the cases, which involved Coleraine Township, Boley versus Coleraine, the entry goes as far as to say MSD and the city are no longer in this case. So I think some of those cases that were cited would not be persuasive in this case to indicate that MSD could not be dismissed. Again, I would reiterate that I don't feel that it was dicta in the lower court. The one statement I'd point to in the order from the second page was that last sentence, in accordance with First District, this court similarly finds that the maintenance of a sewer system constitutes a proprietary function. As such, this court does not find MSD immune from liability in this action. Additionally, there is evidence that MSD has a history of involvement in legal actions. So I'd say that, again, 3 paragraphs, over half of the entry, and definitely I feel like some strong statements regarding immunity that would indicate that the court was making that decision despite the fact that it was not brought up.
And what are you asking us to do? What remedy do you want us to impose?
The city would request that this be reversed on the issue of immunity and that MSD be dismissed as a party.
When you say reversed on the issue of immunity, on the merits or on the argument that it shouldn't be raised sua sponte and the party should have an opportunity to fully argue and brief it?
The latter, Your Honor, not on the merits, but yes, so that it can be fully briefed, discovery can occur. Because again, based on the limited facts of the complaint, it's not clear if immunity is even an appropriate defense.
Well, that's what I understood. You're not asking us to make a substantive finding that there is immunity. You're asking us to reverse the court's statement that there isn't and allow the case to proceed.
That's correct, Your Honor.
So if we agreed that MSD could not be sued, then MSD's out anyway. So what would be the remand for the immunity determination?
Your Honor, city would still be in the case and the county would still be in the case as well. So those 2 parties could go forward with discovery on the issue of immunity.
Which is what, in my mind, might be a distinction with that 7th District case, because there, it was just the one entity, I think.
Yeah.
I think the case
I thought her decision was just MSD. I thought she just decided whether MSD was immune.
That's correct, but Your Honor, I would carry that over to the other defendants as if the immunity issue has already been determined and the city or county tried to raise that at a later date, plaintiff may be able to point to that and indicate immunity has already been decided in this case. And the city doesn't want to go all the way through discovery and motions to run into that barrier in the interest of judicial economy. And if there are no further questions, I would reiterate that the city requests reversal on the issue of immunity, not on the merits, and that this court direct the trial court to dismiss MSD as a party.
Thank you.
Thank
you both for your arguments this morning. We will take this case under submission and give you a timely written opinion. That will conclude the oral arguments this morning for the 1st District Court of Appeals.
For me.